All right, let's talk about propensity evidence. If there is one topic in evidence law that consistently trips people up in the bar exams, believe me, it's this one. Nailing this stuff really separates the good from the great. So for the next few minutes, let's break it down and master it together.
We're kicking off with this quote from Justice McHugh because it gets right to the heart of the whole problem. The entire, really complex set of rules around propensity evidence is built on one single fundamental fear, that a jury, being made up of human beings, will be swayed by their own prejudices, that they might hear about someone's criminal record and just think, well, they did it before, so they probably did it this time. The law knows this is a really powerful, almost magnetic line of reasoning, and its job is to stand in the way.
Here's our game plan. We're going to start with that core conflict, then we'll look at the rule itself and its exceptions. After that, we hit the main event, the striking similarity test, and we'll wrap up with how this all plays out in the real world, beyond just the prosecution's case.
So first up, let's really get our heads around the fundamental tension here. This is the why behind the entire rule, and honestly, understanding this is essential. So, what are we actually talking about when we say propensity evidence? It's any evidence that basically invites the jury to take a shortcut, to reason from a person's general character or their past actions to what they did on one specific occasion. It's that classic bad person, therefore guilty logic.
Now, this slide lays out the single most important distinction you need to burn into your brain for the exams. On the left, that's pure propensity reasoning, and it's a huge no-no. The law is really strict about this. You have to prove the crime with evidence about that specific event, not by putting someone's character on trial. But look to the right, that's the key. If that exact same evidence has a higher, more specific purpose, like proving a motive or identity or knocking down a defense, well, then it might just get in.
And let's be crystal clear on this point. The law isn't pretending this evidence is irrelevant. Of course it's relevant. Common sense tells us that past behavior can be a pretty good predictor of future behavior. The rule exists because the law has made a really important policy call. The risk of a jury being unfairly prejudiced just outweighs how useful the evidence actually is. It's a rule born from a deep suspicion of how we as humans might misuse that kind of information. Okay, so let's move on and see how the law builds this big wall to keep out prejudicial evidence. And, more importantly for us, where the cracks in that wall start to appear. Because that, right there, is where the marks are in an exam problem. Now, that wall isn't completely solid. First, there are some actual exceptions. An accused person can always introduce evidence of their own good character. And sometimes, in civil cases, character is the central issue, like if someone's a fit and proper person. But the biggest crack, the one we're really going to focus on, is that last point. Evidence that gets a free pass because it does more than just show a tendency. It's considered to be outside the exclusionary rule altogether. And this slide right here, this is your bar exam checklist. These are the classic categories where evidence gets let in, even though it reveals someone's bad character. Why? Because it has a specific, higher relevance to a fact that needs to be proven. Is there a history of bad blood between the accused and the victim? That's relationship evidence. Does the crime have a unique signature that points to one person? That's identity. You need to know these categories inside and out. This quote nails the test in a single sentence. It's the core principle you have to apply. So when you're looking at a problem question, you always have to ask yourself, does this evidence show something more than just a general tendency to commit this type of crime? If the answer is yes, that's your argument for why it should be admitted. All right, now we're getting to the peak of the mountain. This is the most complex, the most heavily examined, and the most argued over category of propensity evidence, what we call similar fact or striking similarity evidence. The modern law really all starts here with the famous 1894 case of Mackin. The second part of that rule, the second limb as it's known, is what cracked the door open. It basically said that even if evidence points to other crimes, it can be admitted if it's relevant to a specific issue, like proving an act was intentional, not just an accident, or to tear down a particular defense. This was the original crack in the wall. This comparison is absolute gold for understanding the modern test. On one side, you've got R v. Bear. The court looked at the facts and said, yeah, this is tragic, but legally speaking, it's depressingly familiar. There was nothing so uniquely similar about the offenses that they pointed irresistibly to the accused. Now contrast that with Armstrong. 5 break-ins, same area, short time frame, similar methods, and, this is the kicker, a white car involved every single time. The pattern was so distinctive, it was like a virtual signature, admissible to prove the identity of the offender. See the difference? So then the landmark case of Pfennig came along and caused this massive shift in thinking. For about a century, courts did all these legal gymnastics to pretend this kind of evidence wasn't about propensity. Pfennig just cut right through all that. The High Court basically said, look, let's be honest with ourselves. Of course it is. The new approach was to just admit that it's all propensity evidence, but say that it's only admissible when its probative value is so incredibly high that it totally outweighs the danger of prejudice. So, this is the test. This is what you apply. The judge acts as a gatekeeper. They look at the similar fact evidence and they ask themselves this question. Assuming all this is true, is there any reasonable, rational explanation for it other than the accused being guilty? Could it just be a series of unbelievable coincidences? If there is any rational view that is consistent with innocence, the evidence stays out. The jury never hears it. Only if guilt is the only rational conclusion you can draw from that pattern of behavior does it get admitted.
And if you're thinking, wow, this is confusing, you're not alone. This quote shows that even the courts found the Pfennig test incredibly hard to apply. For years after, different cases created what one court even called a quandary. So think about that. If senior judges were admitting they were confused, you can see exactly why this is such a challenging area, and, of course, a favorite for examiners.
Okay, let's finish off by looking at how these principles work beyond the usual scenario of a prosecutor trying to convict an accused. This is going to give you that complete, well-rounded view that you really need.
The standard of proof here is not a one-size-fits-all deal. When the prosecution uses this kind of evidence, it's held to that incredibly high Pfennig test, which basically is the criminal standard. But when the defense uses it, say to suggest someone else committed the crime, they only need to raise a reasonable doubt. And in a civil case, it's even lower, the balance of probabilities. The standard changes depending on the context.
And here are two perfect examples to make it concrete. In Tchaikovsky, the defense was allowed to show the deceased had a violent disposition. This made the accused claim of self-defense seem much more believable. It wasn't to prove the deceased was violent that night, but to support the accused's state of mind. And in the civil case of Sheldon, an insurance company used evidence of a bunch of other suspicious incidents to successfully argue that the claimant had actually committed arson.
And this brings us right back to where we started. We kicked off talking about the law's fear of jury prejudice, and we've just walked through the incredibly complex, nuanced, and judicially debated rules that were designed to manage that fear. So the final question I want to leave you with is this. Is this whole elaborate structure, one that even high court judges have struggled with, ultimately asking jurors to perform a mental task that is just impossible? That's a question you'll carry with you into your careers. Good luck with the preparation.